Under Section 148, the court to decide when questions to be asked. Section 148 of the Evidence Act 1872 speak about court to decide when questions shall be asked and when a witness is compelled to answer. This section says that when in the course of a cross-examination, question asked to the witness is not relevant to the facts but is asked only to shake his credit by exposing his character, the court has to decide whether or not the witness shall be compelled to answer it. The court may warn the witness, if it thinks fit necessary, that he is not bound to answer it. In deciding as to whether a witness should be compelled or not to answer a question, the court shall have regard to the following circumstances. If the court is of opinion that the truth of the imputation could seriously affect the court's opinion as to credibility of the witness, the court should allow the questions. Thus, in a case of rape, prosecutrix may cross-examine as to her connection not only with the accused but also with other men. However, the court must also ensure that the cross-examination is not made a means of harassment or causing humiliation to her. Improper if the truth of the imputation is very remote in time or is of such a character that it would not affect at all or would affect only very slightly the credibility of the witness as to the matter on which he gives evidence. Questions are also improper if there is a great disproportion between the importance of the imputation and the importance of evidence. If the question is proper and the court asks the witness to answer it, but even so he refuses to do, the court may, if it sees fit, draw the inference that the answer, if given, would be unfavorable to the witness. Section 149, no questions without reasonable grounds. Section 149 of the Indian Evidence Act 1872 speaks about question to be asked without reasonable ground, which this section says that any questions referred to in section 148 are to be asked only when there are reasonable grounds to ask such questions that might injure the witness' character or expose him. For example, a barrister is instructed by an attorney or a vakil. An important witness is a kidnapper. This is a logical ground for asking the witness whether he is a kidnapper. A witness of whom nothing whatever is known is asked at random whether he is a kidnapper. There is no logical ground for the questions. Section 150, procedure when question is without reasonable ground. This section deals with the procedure to be followed by the court in regard to circumstances where an advocate asks a question without any reasonable ground. A report has to be sent by such court to the High Court or other authority to which such barrister, pleader, or vakil or attorney is subject in an exercise of his profession, giving circumstances of the case in which such defamatory questions as were asked under circumstances mentioned in section 148. Under section 151, indecent and scandalous questions. This section empowers the court to prohibit asking any question to the witness which are indecent or scandalous unless it is having a bearing on the case. If it is relevant to the case, it can be asked. A fact that is relevant to a case cannot be said to be scandalous. It is to be noted that a counsel is entitled to present the evidence as best as he can to prove that the complainant and the witness are fake and they are not speaking the truth. But he should not do personal attack on the complainant and the witness by questioning matters which are not borne out by the fact of the case, nor is he entitled to use abusive language against them. Under section 152, question intended to insult or annoy. This section says that where a question is calculated to insult or irate through a paper in itself appears to the court needlessly offensive in form, the court must be between for the protection of the witnesses. Section 153, no evidence to contradict answer testing veracity. This section says that if any question has been asked and the witness has answered it and it is only a cause injury, question has been asked and the witness has answered it and it only causes injury to the witness character, no evidence shall be given to contradict him unless he answers falsely, in which case he will be charged for giving a false statement. There are two exceptions to this section, which are if a witness has been asked whether or not he was previously convicted. On denial of the witness, the evidence regarding the proof of his previous conviction can be given. If a witness has been asked a question that impeaches his impartiality, on denial of witness, he may be contradicted. It means that if a party has sufficient ground to believe that the witness is not impartial, they may contradict him and try to furnish a proof. The object of this section is to prevent trials from extending to an unreasonable length. If every answer has to be given on every fact asked under section 146 and it is met to the subject matter of fresh inquiry, then a trial might never end. These matters are, after all, not of a prime importance beyond what is said to the exceptions. For example, Kamal Taneja claims to have seen Arvind at Delhi on a certain date. Kamal is asked whether he himself was at Haryana that very day or not. Kamal denies it. Evidence is adduced to show that Kamal was actually in Haryana. The evidence is admissible not as a contradicting Kamal on a facts which affects his credit, but as contradicting the least fact that he saw Arvind in Delhi on that same date. Section 154, question by party to his own witness, that means hostile witness. This section allows a party with the permission to the court to cross-examine him own witness in the same way as the opposite party. Such cross-examination means that he can put a leading question under section 143 of the Act. Question about his previous statement in writing under Section 145 of the Act. Question to be given to the test is truth to discover who he is and what is his place in life are seek his credit under Section 146 of the Act. This is clear from Section 154 itself, which does not say that a person who calls a witness may cross-examine him in certain circumstances, but that he might put question to him which might be put in cross-examination by the adverse party. That is not the same as cross-examining him. The utility of a cross-examination under Section 154 of the Evidence Act is that by court can more readily get the truth out of its witnesses, as the witness turn hostile against the party who called him. The permission for cross-examining one's own witness should not be granted to the party at the mere asking. The granting of permission is entirely the discredit of the court. The discretion enforced by the Section 154 is apart from any question of hospitality. It is so to be liberally exercised whenever the court, from the witness demeanor or attitude or a tenor and tendency of his answer, or from a perusal of his previous inconsistent statement, otherwise think that the grant of such permission is an expedient to extract the truth and to do a justice. It is to be noted that there is no precondition to first declare a witness hostile, adverse, or unfavorable, and then grant permission to contradict him and to ask questions which might be put during cross-examination. In a case the witness show any sort of inconsistency or contradiction from his previous statement. A hostile witness, the term has not been used in Indian law, unlike English law, is one who from the manner in which he gives the evidence show that he is not desirous of telling the truth to the court. A witness who is gained over by the opposite party is also termed as hostile witness. An adverse or unfavorable witness is one called by a party to prove a particular fact, who fails to prove such fact or proves an opposite fact. The inference of the hostility of a witness would be drawn from an answer given by him and to some extent from his demeanor or attitude, etc. A prosecution witness can be declared hostile when he recites from his previous statement made under Section 161 or 164 CRPC. Besides this, when a prosecution witness turns hostile by stating something which is destructive of his prosecution case, the prosecution is entitled to get this witness declared hostile. A witness cannot be said to be hostile whenever his testimony is such that it does not support the case of the party calling him, or is not in accord with the evidence of his other witness, when he has not been produced out of the fear that he might disfavor the party who has to produce him, only because he gives inconsistent or contradictory answers. Example, at a session trial, a witness tells a different story from that is told by him before the magistrate.